The budget was one of the top 10 bills to watch for many statewide interests, including Ohio's prosecuting attorneys. But the death penalty, drugs, including marijuana, gun regulations, elections law, and even the definition of burglary are among the issues that have prosecutors' attention. I talked about some of those with the executive director of the state's Prosecuting Attorneys Association. So let's start with the death penalty. We have not seen an execution in Ohio since 2018, though capital punishment is still on the books in Ohio. There are 113 men on death row. There are 3 bills that would abolish the death penalty. We're still waiting on one that was supposed to abolish the death penalty and be tied with abortion as well. In the Attorney General's annual capital crimes report, AG Dave Yost wrote that there's been no change in the death penalty in Ohio except the killers got a year older. And he also wrote, there needs to be some real progress. Until that happens, Ohio cannot fulfill its promise of justice. Do you agree? What do you want to see happening with the death penalty in Ohio?
Well, our association still thinks that there's a place for the death penalty and a need for the death penalty. And we think that enforcement of it needs to be resumed. And all of this undue delay that there's been over the last 6.5 years is really unfair to the victims of these crimes. It's really unfair to the communities where these crimes occurred, to the loved ones and families of the victims. And so we need to find a path to justice for these people. The issue needs to be resolved. We need to find a way forward. I think the public polling on the death penalty supports our position on this. I think most polling, traditional polling, will show you that there's at least more than 50% of the public supports having a death penalty. But I think when you start to ask them about the specific types of crimes that people commit that lead to the death penalty, public support gets even higher. And so when you start to ask them about the murder of children, the murder of police officers, multiple murders or acts of terrorism, support for the death penalty is, in the 70 to 80% range.
But you do have some conservatives who say it costs a lot of money to go through the death penalty process because each one of those people gets a full appeals process all the way up to the Ohio Supreme Court, sometimes even to the U.S. Supreme Court.
Yeah, it is expensive. It is more expensive than a traditional murder trial, life without parole sentence. But we want to make sure that we're providing people with super due process because death is final. We have a justice system that I think, fortunately, death sentences are sought rarely. They're imposed rarely. And they really are reserved for people who have sacrificed the right to be in a civilized society. And so I think the expense is worth it.
You mentioned that death sentences are sought rarely and imposed rarely. Very rare in Ohio, it seems like, in the last couple of years. Is that because there haven't been any executions carried out?
Yeah, I think that is part of it. I think prosecutors are probably more reluctant to seek a death sentence these days because they don't want to put the victims' families through all of the uncertainty that's going on. And I think that's another reason that we need to find a path forward on this issue.
I want to ask you about a bill that's known as the Second Amendment Protection Act, which prosecutors have spoken out against. It would prevent federal agents from taking Ohioans' guns. It got some changes in the last few weeks. But you, along with the Ohio Association of Chiefs of Police, still have concerns about how it would affect cooperation with federal officials, efforts to go after violent criminals. What are your concerns about this particular bill?
Yeah, I think first of all, protecting Second Amendment rights is a totally legitimate policy goal. And I appreciate the fact that the sponsor of this new version of the bill has tried to make some changes to it that he thinks alleviates some of the issues that we brought up in the last General Assembly. But the reality is this is ostensibly about what you said. It's ostensibly about preventing federal officials from coming to Ohio and taking people's guns and from using our state resources to do that. But in practice, it goes way beyond that, and it's going to proactively interfere with voluntary cooperative efforts that we have with federal officials to investigate and prosecute violent criminals who are using guns. I can't express enough how dangerous and how foolish that is. These are relationships that our law enforcement wants to have with the federal government because it promotes the safety of our communities.
And is there a threat of this happening? I mean, we have a Republican White House, a Republican Congress. Is there a threat of what the Second Amendment Protection Act is trying to prevent from actually happening?
I would say certainly not right now.
I want to ask you about this definition of burglary. There was an Ohio Supreme Court case in which a man who stole, he literally walked into a garage in front of the homeowner, stole a leaf blower out of the garage in front of the homeowner. And this came to the Ohio Supreme Court, which said that burglary requires the use of stealth, force, or deception into a structure with the intent of committing a crime. So this wasn't burglary, is that right?
We think it was burglary. Frankly, we think the Supreme Court got the decision wrong. There was evidence presented in this case that the offender drove by his victim's house. He noticed the open garage door. He had a noisy car. He turns the car around. He parks up the street. And he walks back down and walks into this guy's garage and takes the leaf blower. And so there was evidence presented that him parking the car up the street because he knew it was noisy, he knew it was more likely to draw attention, that was the stealth. We don't think appellate courts should be replacing their own factual opinions with the decisions of juries. But at the end of the day, the decision is what it is. We think the law should be changed to get rid of the requirement that there be forced stealth or deception. Our burglary laws are about protecting the sanctity of the home and recognizing the increased danger when people enter the home through any means with whatever their intent is. And so we think people would be shocked to know that somebody could do what they did, what this guy did in the Bertram case, and walk away with a misdemeanor trespass.
I want to ask you about marijuana. There's been obviously the voter-approved law that went into effect, but there's been talk of changing that law. What's it been like to prosecute cases related to marijuana and keep up with everything that's going on with that?
We support some legislative action on this. I think we would like to see the number of home grow plants reduced from 12 at least to 6. I think we need to see some additional statutory regulation on how in particular, edibles are produced and marketed to children. They shouldn't be produced and marketed in ways that are attractive to kids. But overall, I would say it has gotten a lot more difficult to prosecute marijuana cases. There's a huge delay even in testing whether something is marijuana versus hemp at BCI and at the Attorney General's office, just because there's so much product around. Obviously, there are new challenges with proving whether somebody's illegally purchased the marijuana or illegally purchased the marijuana now. So it has created a variety of challenges for prosecutors and for law enforcement.
I want to turn to juvenile justice. Governor Mike DeWine vetoed a provision of the state budget that would have transferred youth offenders convicted in adult court to the Department of Youth Services. He said that would have forced kids who've committed lower-level crimes to, in his words, interact with incredibly dangerous offenders. Is that a veto that you support, oppose? What do you think should happen to these kids who are tried in adult court, but they are still kids?
Yeah, certainly I don't disagree with the governor's veto. That juveniles who are tried as adults and who are sentenced to prison are housed in separate units at DRC anyway. So I don't think that there's a huge impact on them until they turn 18 in terms of whether they're housed at DYS or DRC. But look, I think overall juvenile crime is, a lot of our prosecutors would tell you, is the number one criminal justice issue they face in their communities. I think there's a huge lack of accountability for some repeat juvenile offenders, even violent repeat juvenile offenders. You can see this in the stories about all the cars that are stolen by the Kia Boys and other groups of kids, all the vandalism that occurs and the break-ins of cars. And so I think we need, at the end of the day, kids who are committing these things and doing it over and over and over again without any consequences, not only is it bad for the community, it's bad for the juvenile themselves, because what's happening is they're learning that there aren't consequences for their actions, and eventually they're committing an aggravated robbery or some sort of a homicide offense, and they are transferred to adult court and they're facing serious time. And so we think we need to change the incentives for juvenile judges to, we're not talking about locking up kids and throwing away the key. We're not talking about transferring everybody to adult court, but some additional accountability when we have these repeat crimes.
There is this balancing act, though. When kids are in the juvenile justice system, there's the emphasis on rehabilitation, whereas in the adult court system, there's a little bit more punishment. Yeah. And so you're trying to balance that out, aren't you?
Yes, and there does need to be a balance, and there are absolutely benefits to keeping kids in the juvenile justice system, up to a certain point. And there are absolutely benefits to keeping a lot of kids in a community setting on probation up to a certain point. But when you have kids the seriousness of their offenses are escalating, they're being arrested and released the next day or within a few days, and they're going back out and doing it again.
You've described this as a revolving door.
As a revolving door or catch and release. There should be some detention and some consequence for that. Because otherwise, you're putting the kid at risk and you're putting the community at risk of greater harm.
You and Secretary of State Frank LaRose had a public disagreement last year when he accused local prosecutors of languishing and going after 633 cases of alleged voter fraud. You defended those prosecutors, saying the cases often lacked minimal evidence to even pursue an indictment, much less get a conviction. Governor DeWine vetoed a provision in the budget on an election integrity unit and the requirement that prosecutors must take action within a year. You had concerns about a bill that would require that action within a year.
Yeah. So we support what the governor did in his veto. He didn't veto the election integrity unit in its entirety. So there is going to be this statutory entity in the Secretary of State's office that's going to be charged with receiving and investigating allegations of elections fraud. The two things that the governor vetoed were the two things that really were the biggest concerns to us. One was this idea that if a county prosecutor declines to prosecute one of these cases, the Attorney General would be able to review that and come to his own conclusion. The Attorney General has never been like an appellate reviewing body for prosecutor charging decisions in Ohio, one, and two, that created the possibility of forum shopping. So you don't like the conclusion that the county prosecutor comes to, you take it to a different entity and see if he comes to a different conclusion. And then secondly, the expectation from the other thing that was vetoed was that prosecutors would pursue these cases and seek indictments based on a minimal level of evidence, something that's enough to obtain the indictment, but not enough that would be to obtain a conviction. And so prosecutors are ethically obligated to only present things to a grand jury and only proceed to trial if they're reasonably confident that there's going to be evidence beyond a reasonable doubt to obtain a conviction. And there was language in there that was basically requiring us to seek an indictment before we were assured of that.
So this whole idea that prosecutors could indict a ham sandwich if they wanted to, you hold yourself to a higher standard than that.
I would say that's not true. They could, but ethically they would not do that. The last thing I'll say about that is, we totally agree with the Secretary of State that these offenses need to be taken seriously. There are a small number of them, but there are a small number of other types of crimes, and prosecutors need to prosecute those too. Election integrity is real. We need to be sensitive to election fraud. Voters don't like it. And I'm optimistic that the governor has struck a good balance between what we wanted and what the Secretary of State wanted, and that we can have a collaborative effort going forward.
What is the workload like for county prosecutors? Because there seem to be some efforts to try to turn a lot of things over to local county prosecutors to take care of them. What's the workload like for county prosecutors?
They have a heavy workload right now, and one of the bigger issues that prosecutors are facing today is recruitment and retention. And so a lot of offices are understaffed. They're working long hours. Most prosecutors and assistant prosecutors are working well beyond a 40-hour work week. And so we are sensitive to kind of new responsibilities and new workload being given to us.
Do you have kids who are coming out of law school who are looking at positions in big firms rather than, that's going to pay more than what you pay?
Yeah, that is certainly part of it. They're long hours, they're emotionally charged issues, they're difficult issues with weighty decisions. And like you said, most often for not as much pay as you could go make in the private sector. And so that is certainly part of it.
And that's something you share with, for instance, judges in the system.
Yeah.
You have the same challenge there, I think.
Absolutely.
On that note, I want to ask you about a group that wants to end qualified immunity in Ohio for government employees. That would include police officers, prosecutors potentially. They're gathering signatures to put an issue on next year's ballot. That idea may have some support among people who say that they want police officers and others to be held more accountable to some of the things that, the high-profile things that have been happening. Are you concerned about that issue getting the ballot?
We are very concerned about it. It would be absolutely devastating to law enforcement and absolutely devastating to prosecutors, and consequently devastating for public safety in the state of Ohio. And it does tie into the recruitment and retention issue. I think, like I said, these are very difficult jobs. Being a police officer, being a prosecutor, long hours, emotionally charged and emotionally intense cases. And it's going to be even more difficult, if not impossible, for us to recruit people to these jobs if they're constantly worried about a lawsuit hanging over their head. And I think beyond recruitment and retention, it's going to reduce the effectiveness of the law enforcement and prosecutors that we currently have and that we can convince to become prosecutors and law enforcement. You're going to have law enforcement that hesitates to engage in certain situations or decides not to engage at all. You're going to have prosecutors who are reluctant to take on complex cases or controversial cases because of fear of a lawsuit. You're going to have bad actors who use lawsuits to intimidate prosecutors or law enforcement or tie them up in litigation. And you're going to have people who suffer reputational damage because of lawsuits who have done nothing wrong. You know, the whole purpose behind and policy behind qualified immunity is that we want to encourage public servants to be able to do their jobs. They have difficult jobs. They have to make difficult choices on behalf of the public good. And we want them to be able to do that without fear of constantly being sued. And we have to recognize that this is a human system. Humans make mistakes once in a while. We can't have the public being sued all the time for mistakes that are made.